regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. We're going to be talking with Tony Aiello from Oregon here in just a minute or two. You know, Tony is the lead attorney in the state-level challenge to Measure 114. That is the ballot initiative that was approved 4 years ago almost in Oregon by the narrowest of margins, less than 51% of voters approving the permit to purchase and ban on magazines that can hold more than 10 rounds. That law has been on hold ever since because of the legal challenge. And basically two separate legal challenges, one in federal court, one in state court. The Oregon State Supreme Court is now reviewing the lower court decision that held the law unconstitutional. The federal lawsuit is on hold until the state cases are resolved. Meanwhile, you've got lawmakers in Oregon who are trying to revise the provisions of Measure 114 to increase the fee charged for a permit to purchase, among other changes to the law. And not just a minor, $5 increase. I think it's going from $50 to $150. I mean, it's pretty bad. So wanted to get folks up to date. I had written about the legislative side of things last week, and I completely forgot that Measure 114 is actually subject to a injunction at the moment. If it was not, then Measure 114 would be slated to go into effect in March of this year, just a few weeks from now. And it is possible, if the Oregon Supreme Court comes out with its decision between now and then and says, yep, the law is fine and dandy, that injunction will be lifted and the law could soon take effect. But we don't know when the Oregon State Supreme Court decision will be, nor do we know what the decision will be. Speaking of Supreme Court, the U.S. Supreme Court issued its orders list today, and no action taken on the gun bans, magazine bans that were before the court. So likely these cases are going to get relisted. They could just kind of be put in limbo, like we've seen with the multiple challenges to gun laws dealing with adults under the age of 21. Those have not been relisted in conference. They have not been granted cert. They have not been rejected. They're just sort of out there, meaning that the court plans on doing something with them. Whether it's, GVR in these cases after the decision of Wolford versus Lopez or U.S. versus Samani, we don't know. But they did dispose of a number of challenges under Section 922G1. This is the ban on firearms for those convicted of a crime punishable with more than 1 year in prison. They rejected most of those cases, not all of them, though. They're still holding on to a case called Vincent versus Bondi. That's the case of Melinda Vincent, a woman in Utah who was convicted of writing a bad check. I think it was 17, 18 years ago, given probation, but it was punishable by more than a year in prison. Since that time, Melinda Vincent has really turned her life around. She's a drug and alcohol counselor now. She would like to be able to own a firearm for self-defense, but she also wants to be able to teach her kids how to shoot responsibly. The Supreme Court has held on to that case, even though it has rejected several other 922G1 challenges. So, again, don't know what that means, other than maybe potentially good news for Melinda Vincent. But we do expect another conference this Friday, and we'll be looking to see how many of these 2A cases have been relisted. Right now, though, let's turn our attention back to Oregon and welcome Tony Aiello to the program. Take a look and a listen. Tony, thanks so much for coming on the program today. It's good to see you, sir.
Absolutely. Thanks for having me.
Yeah, and, I know that things are, things have been in flux for Measure 114 since shortly after it was passed by the narrowest of margins. But I guess it's even more in flux right now, right? Because we've got this legislation that could postpone the effective date, but also make some real fundamental changes to this bill, including raising the fees for a permit to purchase substantially, right?
230%.
Good Lord.
Yeah.
All right. So what's the status of that legislation right now?
Yeah. So HB 4145, we're recording right now at 9 a.m. Pacific. So it's going to be read on the House floor at 10 a.m. unless it's carried over again. It was carried over on Friday as part of the, jostling and negotiation between the majority and the minority on what bills have priority and is there a walkout if things aren't prioritized right? So everything's in flux. This has been my life every single session since December 8th of 2022 is, okay, are they going to pass a bill? What's that going to do to my case? And it's a different version of the bill every time it comes forward.
Yeah, yeah. This is not the first time that they've tried to make some changes to Measure 114, right?
Uh, Correct. Yeah. It's been every legislative session, the same legislator, Jason Kropf, has proposed something. It's different every time. You can kind of tell he wrote it himself. I guess he's a lawyer who fancies himself quite the bill writer. Uh, and he does things.
Have any of those previous measures been successful? Have any of them been adopted?
No, they've all died in committee, which is what we're optimistic is going to happen here. Or none of them have been voted down in committee, though we came very close to this time. And and yeah, so one bill did pass last session, which is Senate Bill 243, which didn't mainly deal with ballot measure 114, but it did postpone the effective date, which is causing some confusion with people. People still think March 15th, 2026. That is what the law says, but we still have a permanent injunction against what's called the operative clauses of ballot measure 114. So that would be like the prohibition. It is a crime too. We have a permanent injunction against that. So changing the effective date doesn't change anything for gun owners or gun stores.
Okay. Unless or until the Oregon State Supreme Court comes out and says, yeah, this law is hunky dory, right? We don't have any issue with it.
Yeah, if we were to lose the case, the normal process, which you never know because there's nobody to complain to when you're dealing with a Supreme Court, so they can kind of do whatever they want. But the normal process is they kick it back to the trial court. So they say, trial court, you enter a judgment consistent with our ruling. They make him lift his own injunction. And the way things have traditionally gone in Judge Rashio's court is he'll tell you when he's going to rule. So he'll say, parties, get me a judgment by, Monday. I will enter the judgment by Thursday. And so everybody knows what's going to happen and when. He's done that a couple times for us where he came out ahead of time because you don't want people unwittingly breaking the law.
Absolutely. Yeah, absolutely right. Let's just say, and again, I've got no knowledge of this happening, but let's say the Oregon State Supreme Court came out tomorrow and said, yeah, you know what, Judge Rashio was wrong. The law is fine. And Judge Rashio then enters that judgment. Is the state ready? Like, if March 15th comes, is the state ready to implement this permit to purchase system? It sounds to me like they're not.
Well, and it depends on who you ask. I mean,
Okay.
it's one of those things where with a ballot measure, these are not written with the help of legislative counsel. So there's certain ways we write bills in Oregon. I don't even know them all, but kind of like a journalistic practice where it's okay. Do we capitalize this word? Yes or no? Or do we, have interrupting commas or things like that? And so there's a certain amount of tinkering that has to be done with every ballot measure after it's passed. And so what's been interesting here is we've had we've had some form of injunction from December 8th, 2022, which was the date this was supposed to go into effect. So I do understand the urge to tinker, but while it's being decided in the Oregon Supreme Court, especially after oral argument has already happened. So there's no question of, is the court going to take the case or are they going to take the whole case? Last session, I think they had a better ground to stand on, frankly, for tinkering with it because they had a ruling from the Court of Appeals. Supreme Court hadn't agreed to take the case, that they take very few cases. So that would have made more sense. This time it seems a lot more underhanded.
To at least wait until the Supreme Court decision comes out. Yeah.
Yeah.
And that, I mean, that does make sense. I don't know that the legislature always does what makes sense. So this is
No, and
still
this is more about getting a feather in his cap, I think, than it
okay.
is about the law at all.
Yeah.
Because he's willing, Jason Crop, Rep Crop, he's willing to move things out to 2027. My proposal when I sat down with him in his office was, why don't we move things out to 2027? We know we'll have a ruling by then. And then that'll give you time during the long session. Because right now we're on a short session. It's 35 days. It's a sprint. Um, we'll have time in the long session for permit agents to come in here and tell you, um, you know, this language gives us trouble here, or our insurance is concerned with this part. And then we can tinker. And at that point, even gun owners and 2A supporters have to come to the table, because we do want the permit process to function if we're going to have to live under a permit for some length of time.
Yeah.
We want to understand what magazines are banned if we're going to live under a magazine ban, because we don't want accidental criminals. So there's a 10,000-pound gorilla in the room. It's called constitutionality. Until we have an answer on that from Oregon Supreme Court, I'm not going to help write language to screw us.
Right.
And the permit agents, the most of the county sheriffs are going to be against ballot measure 114.
Yeah.
I think, it only 114 only passed in 6 out of Oregon's 36 counties. And even at the county level where it passed, normally the sheriffs are a lot more conservative. We see that in Washington County.
Mm.
Or at least pro-gun, I guess I can say. And
Right.
so, there will have to be tinkering, and everybody should be at the table. But Mr. Crop wants to do it all by himself.
Yeah, Mr. Croft also made some headlines for how this bill was dealt with in committee. Right? Were you
Yeah,
there for this hearing when he pulled a lawmaker? So, for those who don't know, I wrote about this on
yeah,
Friday, I believe it was. During the committee hearing for this legislation, there was a Democrat who voted against amending Measure 114. Representative Croft, who's the author of this, got very upset. Ended up basically calling a halt to the proceedings, pulling her out into the hallway for about 20 minutes or so. There
yeah.
were reports that she was left in tears. They then go back into the meeting. He gavels it back in session, calls for a do-over on the vote. And she's kind of confused about what we're doing. And then ultimately she switched her vote to yes, allowing the bill to pass out of committee. Um, so were you there for all of that?
No, so I was watching live from my office, but
Okay.
what was interesting is my friend Derek was there.
Yeah.
And
Derek
so
LeBlanc.
I hit, yes, Derek
Okay.
LeBlanc. So I hit refresh and came in when they were coming back in from, when Kropf and Tran were coming back in from the hallway. And then I watched the revote take place, and I was confused why there was a revote. But we felt pretty solid on Tran being a no vote, so I wasn't actually expecting it to change. And then I heard her voice, and I was like, she sounds upset. She sounds like she just got an earful. Um, and so I noticed that without having seen the first part. Well,
Okay.
Derek, he was in the room. And so he watched the first vote take place, heard Crop's side. So it was interesting that without me even seeing the setup, we had the same interpretation of what happened when it came back in.
Mhm.
The big news today is there was a state trooper who witnessed the event that we are expecting is going to come forward today. Um, I guess what I've gathered is he was pretty close to intervening in the hallway. So that's the information we have, is that it was a pretty boisterous conversation. It wasn't a polite exchange of ideas. It doesn't sound
Yeah.
like.
Well, I mean, even Representative Tran said that Croft
Yeah.
created a hostile work environment,
Yep.
in that encounter, and that these we're talking about, two Democrats talking about each other here. That's pretty
Yeah.
unusual. So I know that Derek LeBlanc filed basically a complaint against the representative. I guess sort of an ethics complaint. And I guess that will continue as well. So I mean, again, there's so much surrounding Measure 114, and what this means for gun owners. We also even have the federal case, right? So that's been on hold,
Yeah.
largely while the state case makes its way up to the Supreme Court. But once the Oregon State Supreme Court issues its decision, if they say yes, the law can go forward, well, then the federal lawsuit will then be appealed to the Ninth Circuit, right? Is that
The,
correct?
so that's not the holdup. Right now, the Ninth Circuit has parked um, the federal case, which I know off is one of the plaintiffs, Oregon Firearms Federation.
Mm-hmm.
It's actually five cases in one.
Okay.
So I don't know all the plaintiffs
So
off the
they,
top of
so
my
the
head.
Ninth Circuit they've got a hold of the case, but they've parked it for the
They've
last couple of
parked
years.
it behind Duncan v. Bonta,
Oh,
which dealt with magazines, and then because Gators Custom Guns is criminal, that moves differently. So that's why that was able to leapfrog ahead.
okay,
Is it went through the state court process, and then it's a direct appeal from from the Washington Supreme Court to the U.S. Supreme Court.
okay.
Uh, and so that one's kind of been fast tracked because it's criminal in nature. And so that's what's been disappointing is we have two parts here, a magazine and a permit
Mm-hmm.
issue. And they've parked the entire case because, it doesn't make sense to decide a magazine ban after we've already decided a magazine. And I'm just going, but there's the permit aspect too.
Right.
And this case has been frozen. We got the results from the trial court, from the federal trial court mid-trial in my case. So that was September of 2023. It is now
Wow.
February of 2026, and it has not even been briefed at the Ninth Circuit. So they still got to go through briefing, the three-judge panel, potentially an en banc panel.
Yeah.
Uh, it's going to take a long time so the odds of that case winding up moot because if ours fails,
Mm-hmm.
is tremendous. And then even if ours succeeds, it's moot. So that case, um, I'm not holding on to right now. I mean, great idea. Um, it's just the timing of everything has been odd. So whether Duncan v. Bonta or Gators Custom Guns moots out the magazine issue, or if our case moots out the magazine issue because we win, um, there's a substantial likelihood that that case never even gets fully briefed in the Ninth Circuit, which
Okay.
is unfortunate.
Yeah. Yeah, it is. So with all of these moving parts here, I mean, what's your advice to Oregon gun owners right now? What should they be doing?
Yeah, writing the legislators for sure.
Okay.
Right now, HB 4145 is set to have its third reading on the House floor today. If it gets carried over again, I'm going to start getting optimistic that they're tabling it, which means it's not going to go forward. If depending on what committee it gets referred to, that could spell doom for HB 4145 if it goes to what's called a dead committee, a committee that's not going to be having any more work sessions this session. That would be a good sign for us. But really, it's about convincing, 114 failed in 30 of Oregon's 36 counties. Some of the Democrats, that's their district. And so explaining to them, hey, you should not vote for this. We've got an issue of constitutionality out there. We've got an open case. This doesn't look good for the legislature to be tinkering with a law that's before the Oregon Supreme Court.
Mm-hmm.
Just trying to break through that wall to them
Mm-hmm.
is good. I'm told that there's some mild Democrats that are pro-gun, or at least play pro-gun on TV sometimes,
Okay.
and hopefully they're going to vote no. But yeah, we're just kind of clenched and ready for the next fight. Um, it's out of our hands right now until it's before another committee that we can yell at.
Right. All right. And last question for you, Tony. Whether it's this House bill or maybe even next session, if Measure 114 does eventually take effect, and the legislature comes back and says, "Yeah, well, you know what? We are going to raise the fee for a permit to purchase by 230%." Does that create a new a new claim for you? Could you refile a lawsuit saying, "Okay, look, now this fee is we're arguing this fee is excessive, and this is a new cause of action."
Certainly. HB 4145 as written and the prior versions of it restricts challenges to the constitutionality to Marion County, which is where our state capital is,
Okay.
which is one, it's thumbing their nose at the Eastern Oregon judge. Because as we all know, Eastern Oregonians are second class citizens in the state of Oregon. So says the Democrat Party. They don't vote the way they want them to. And so they don't afford those counties any respect whatsoever. But it creates an interesting issue because what you're talking about is an as applied challenge. As applied to me, this fee is excessive. And the interesting part about that is that would have to be filed in Marion County. So now the Marion County voters who elect the Marion County judges have a greater say in the constitutionality of a law that affects all the counties. And the person who can't afford the 230% increased fee in, Burns, Oregon, which is where our case was litigated, now has to travel 7 hours to Marion County for the privilege of challenging the law. So I know how much gas money and hotel money I spent in my case,
Right.
traveling across the mountains to go litigate, and to force somebody to do that. I don't know how they look at themselves in the mirror.
Yeah. Yeah. So that provision alone, you think would be
Yeah.
challengeable. Interesting. We've got
Oh,
something
certainly.
similar going on in Virginia right now with the Democrats trying to force this redistricting. They had a
Mhm.
provision that the only challenges can only be filed, I believe, in Richmond County, state capital, in an attempt,
Yeah.
I think, again, to ignore, the will of Virginians in other parts of the state. And a judge in Tazewell County said, "No, that's unconstitutional. You can't do that." So
Yeah.
we'll, these type of machinations, I think, are going to become more commonplace, unfortunately, and not just with Second Amendment issues. But Tony,
Yeah.
again, I really appreciate you carving out a few minutes today. I know that you're a very
Absolutely.
busy guy, but I think that you've explained things so succinctly and understandably that I have a better appreciation of where things are.
Yeah.
And if folks want to, continue helping out, what can they do? I know you guys have a Give Send Go.
Yeah.
What's that money being used for?
Yeah. So that's we've been self-funded since trial.
Okay.
So uh, I left Burns on I think it was September 23rd, 2023. And since then there was some post-trial work, um, and then appeals. The state's gone out of their way to make this case more expensive than it needed to be. We had 2 trips to the Oregon Supreme Court before trial on what's called mandamus review, and then we had we essentially had to deal with the appeal twice because they tried to stay the trial court's judgment when we got to the Court of Appeals. So we had to argue it all really quickly in writing, and then rebrief for the argument on the merits. And so they've made this terribly expensive. My firm has been funding my work. So what that means to those watching is my boss is paying my salary to do this work, even if we're not getting paid.
Okay.
And so we're trying to cut into that as much as possible. That's what the
Yeah.
Give Send goes for.
Okay.
Because we don't have, you hear a lot of these lawsuits are funded by the FPC or the NRA. We don't have that funding, and no fault to them. They're doing the federal case.
Right.
That's where they thought the win was going to come from. Uh, and so, yeah, so we've been self-funded this entire time, so that it essentially helps my boss mitigate the losses.
Okay. Okay. And I mean, if this case gets appealed to the
Yeah.
U.S. Supreme Court, right? Because that's the next stop after the Oregon State Supreme Court.
No, not my case.
No? No, it
No,
would not
no,
be?
my case is only under Article 1, Section
Oh,
27
okay.
of Oregon's Constitution. That
This
was a
is it.
strategic, yeah, that was a strategic decision for a couple of reasons. One, we didn't want to get removed to federal court
Mm-hmm.
um, with the rest of the plaintiffs, because then why are we there to
Okay.
make the same arguments they would
Yeah.
make? But the other reason is Oregon Supreme Court has interpreted Article 1, Section 8 of Oregon's Constitution, which is our free speech provision,
Mm-hmm.
more strongly than our First Amendment. Right. And so our argument there is the same. The founders of Oregon wanted us to have greater gun rights than the federal government provided in the Second. And so that's our argument. And the case law as it sits today, that's true. Now, the Oregon Supreme Court has it now. They can change the case law. No one to complain to. But if they stay true to the law as it's been, the first Article 1, Section 27 case was issued in 1980. So if they stay true to what it's been for 46 years, we're going to win.
Okay. Well, Tony, listen, again, I cannot thank you enough for coming on the program today. I know we'll be talking again in the future. Thanks for everything you're doing. Say thanks to your boss for us on behalf of the country, and have a great rest of your day.
Thanks, Cam. Have a good one.
My thanks to Tony for joining us on the program, and of course, we'll be keeping you up to date on everything that's going on with Measure 114 going forward. Right now, let's turn our attention to today's armed citizen story, our good deed of the day, and our recidivist report. We'll start there from Baltimore, Maryland, where a repeat violent offender has been arrested for killing a father of three inside an East Baltimore convenience store. This while the individual in question actually wanted for violating his probation. According to CBS in Baltimore, the clerk in this convenience store, Khalid Saleh Muhammad al-Shariki, was shot and killed on Friday, February the 13th, by a suspect who then calmly walked out of the store after taking what little cash there was in the cash register. Police identified that shooter as 52-year-old Brian Burrows. They said that 2 days after the murder, Burrows committed another armed robbery at a store just about a 10-minute walk away from where al-Shariki was killed. WJZ investigated Burrows' previous criminal history, found he was on supervised probation, or supposed to be on supervised probation at the time of the killing, and, quote, appeared to have been given many second chances. He was released from prison last year for an armed robbery that was committed in 2018. For that crime, Burrows was sentenced to 20 years in prison, but the judge suspended the vast majority of that time and allowed his release after 7 years. So after he was released, and I believe released in January, he was supposed to go to rehab as part of the terms of his probation. May 12th of last year, he gets released from a substance abuse treatment program because he violated the zero tolerance policy. He was then sent to a detox program, but left 2 days later. July 11th, he was sent to a behavioral health program. July 29th, he OD'd and was hospitalized, sent to yet another treatment program. Left on August 3rd against medical advice, and that's when parole and probation lost track of him. A warrant was issued for his arrest on September the 10th, but it wasn't until February 19th when police found him, and of course at that point, he was already wanted for murder. WJZ reports that court records also show a felony drug crime in 2017, the year before the first armed robbery. Burrows actually was sentenced to 15 years in prison for that crime, but the entirety of the sentence was suspended by a judge. So this is, again, not uncommon, not just in Maryland. You have individuals who are charged with violent offenses, and a judge says, okay, we're going to sentence you to X number of years, but we're going to suspend almost all of that. Or some cases, we'll suspend the entirety of that sentence. And instead, we'll put you on probation. So on paper, a prosecutor can argue, well, yeah, this guy got 20 years in prison. No, he didn't. He got 7. And frankly, the fact that he served most of those 7 years is pretty surprising. I don't know what Maryland's policy is for time off for good behavior, but in a lot of states, 7 years ends up being 3.5 years. And in this case, again, 7 years, apparently not long enough for Mr. Burrows, who now stands again accused of murder. Today's Armed Citizen story from Arizona, where an intruder was shot during a break-in early Monday morning at an apartment in Gilbert, Arizona. We don't have a ton of information because, again, this happened not long ago. Actually, I guess it was early Sunday morning, about 4:30 in the morning. Gilbert police got reports of a unknown trouble at an apartment. 911 caller told dispatchers that an unknown man had broken into their apartment and was assaulting somebody. At that point, one tenant opened fire, striking the alleged intruder. When officers arrived, they found the suspect, who was suffering from pretty serious injuries. He was taken to the hospital. At last report, remains in critical condition. Nobody inside the apartment were seriously hurt, thankfully. Police in Gilbert continuing to gather additional details. Doesn't sound like the tenant, though, was arrested, charged with any crime. At this point, looks to be a case of self-defense, but we'll give you any more updates as they become available. And finally, today, our good deed of the day. In the right place, at the right time, willing able to do the right thing. A Georgia police officer who saved a newborn baby during a traffic stop when the child wasn't breathing. Cobb County police officer William DeSaucer, I believe, was involved in a traffic stop. Then the dad runs up to DeSaucer and says his wife's in labor. Said, I don't think we're going to make it to the hospital. By the time DeSaucer, radioed for an ambulance, then goes up to the car, he said the baby was already born, but the newborn wasn't breathing. So DeSaucer's on the phone with a Cobb County 911 operator. He starts performing CPR. Desmond Harris with the Cobb County 911 office says it's very rare you get a call from one of your own officers who need your help. The dispatcher jumped into action, followed protocol, gave DeSaucer instructions on how to perform infant CPR. He did perform about 3 rounds of that before he said, I noticed I started to see some arms move, and then I saw the baby sticking out her tongue. DeSaucer says he's just happy that mom, dad, and baby are all good, and apparently they are. They made it to the hospital. The little baby was checked out, and it looks like everybody is going to be fine. So in the right place, at the right time, willing able to do the right thing. Cobb County Police Officer William DeSaucer and that 911 dispatcher, frankly, who will walk DeSaucer through performing infant CPR. Both of them doing exactly what needed to be done in that moment to save the life of this newborn child. So we thank you very much for your very good deed. That is going to do it for this edition of Bearing Arms Cam & Company. I do want to thank you for being a part of the program as always. Be sure to check out BearingArms.com throughout the day today. We're keeping you up to date on all of the latest Second Amendment news and information from all across the nation. We'll be talking with our friend Dan Wass on tomorrow's program about some of the stuff that's going on in New York State. I'll be joining Carl Higbee on Newsmax for 2A Tuesday in the 6 p.m. Eastern hour tomorrow as well. So be sure to tune in for that. Have a great rest of your Monday, at least as good as Mondays can be. If you are in the path of this winter storm, my fingers are crossed for you. I know producer Jim is looking at about 3 feet of snow potentially. So, again, to all of you folks who are being impacted this winter storm, I dealt with that last month. I don't envy you, and I am wishing you guys that your power stays on, that you're warm and dry, and that you are as safe as possible. Until we talk again, be well, be safe, and be free.